All right, the Ryan P. Mulvaney, lawyer, litigation, sports, NIL entertainment, all of the above. It's Stevens and Lee joins us on 365 Sports. Hey, man, I appreciate you. I've seen a lot of what you've said. I've seen people quote you for what's going on. Craig Smoke, David Smoke, 365 Sports. Ryan, I know you know law. You know all of this, but do we? I mean, do we really know what in the hell's going on in the NCAA and college sports?
Frankly, only Judge Wilkin knows. First and foremost, thanks for having me. And second of all, scataboo.
Yeah.
I'm a Giants fan, so I'm very, very happy.
There you go.
Yeah, looking forward to watching him play in the New York Giants jersey. So congrats to him. Looking forward to seeing him play in the Meadowlands. Only Judge Wilkin knows, right? She only knows what she's going to do. We have the submissions from the NCAA and conferences that were filed the supplemental on April 14th. So they took the position that they were going to work with some of her suggestions, but not necessarily on the roster limit issue. And she basically said, go back to the drawing table, right? I want the roster limit issue addressed.
Okay, well, it was almost like, were they just being stubborn? Because that's why the NCAA is in the position they're in. Like, well, she really doesn't mean that. And we are the NCAA, even though we've blanked everything up now for decades. Was that a ballsy move or a dumb move on their part?
Well, it certainly wouldn't be something that I would do. Having litigated in federal court here in New York and New Jersey and Pennsylvania and Connecticut, and having clerked for a United States district judge out of law school, you kind of learn to read the tea leaves here, right? This, for all of your viewers, this was even more interesting because this was out in the open. Usually these conversations between judge and counsel, where she's kind of showing you the tea leaves, occur inside chambers, right? So we really don't see this out in the open. This was in an open forum in the middle of a fairness hearing on this very settlement. And she said, here are the problems I have. And if you want this finally approved, if you want my opinion on final approval and my order blessing this, then here's what you're going to have to address. Look, again, it's something I wouldn't have done. Once you have those moments in court, you go back to your client and say, here are the tea leaves. So I don't think it was necessarily the lawyers. Maybe it was the NCAA and the conferences saying, look, we heard her, but this is what we're going to do. And look, that didn't go over too well, even the second time.
Mm-hmm.
So we'll see what they do in the coming days.
So the roster limits is the thing that's holding this up, and you brought that up. But how do you think that's going to end up, Ryan? Where that scratches, I guess, her itch of, is it, we'll do 130, then 125, then 120? Will it be a slow? How do you think that will work?
Look, I think ultimately it has to be a gradual process. And why is that? Because for her to grant final approval of this proposed and preliminarily approved class action settlement, she's going to have to find that it is fair, reasonable, right? Fundamental fairness to all involved. And what she is seeing is the very practical situation where you have hundreds and hundreds of student athletes who are entering the transfer portal, not because, as defendants say in their papers, that they have made their own independent decisions. Look, I have clients who were told that they have no roster spot for them anymore.
Mm-hmm.
To enter the transfer portal, that's not a voluntary decision. That's, hey, we're breaking up. You have no spot here. What are you going to do? You have to enter the portal. And what her problem is, and it's very clear, this settlement negatively impacts college athletes who are in college today, right? and your high school seniors who have committed to a university and who have been guaranteed a roster spot, only to have that roster spot taken away. That is her problem. And when you talk about fundamental fairness, when you talk about the standard that has to be satisfied here, I think she's having a hard time finding that a settlement that is negatively impacting people who are in college today is somehow fundamentally fair to the whole. So I think, look, at the end of the day, she has two choices to make. She either denies final approval of the proposed class settlement on this singular issue, or she tells them to go back to the drawing board, which she's already done. Mm-hmm. And we'll see what the NCAA and what the defendants do, the conferences, and the plaintiffs. But those are her options, right? She's already done this now 2 times at the fairness hearing. She's told them, address this issue. Hundreds of objectors with respect to the roster limit issue. They've addressed some of the other issues, but they have not, to her satisfaction, addressed the roster limit issue. And that's going to be a problem.
So, Ryan, and again, thanks for your time. We have had a handful of the Big 12 football coaches on in the last week or 2 or 3 or 4 with spring football, and then some of them have wrapped. Most everybody, in fact, has wrapped it up. And they have had those conversations. Like Chris Kleiman even said, I got to sit down in front of like 25 or 30 of these players who are the backbone of the history of how K-State football has been put together. Sure. Guys who have gone on to play in the NFL as walk-ons, etc. So with her sending that back, if a coach has talked to a player that we no longer have room, and then the House settlement passes with roster limits being raised, can those players go back to said K-State or wherever else?
Well, not if they've committed to somewhere else and they've signed revenue sharing and things like that. But sure, if they're in the portal and suddenly tomorrow we have, final approval and we have the roster limit issue addressed to the judge's satisfaction, they can certainly go back to their universities. It's funny you mentioned that because, look, kind of being on the ground in this and representing athletes and hearing some of their stories and sitting through the fairness hearing for 4+ hours and hearing the very real stories of some of the athletes who spoke. I can tell you this, it seems like the defendants in the case saw that preliminary approval was granted, and yeah, we did have the roster limit issue there. And I believe the schools, the conferences, NCAA took that as, we're going to get final approval, so let's start implementing all these changes now, in my opinion, prematurely, because you have these very conversations, right? You have coaches telling kids, we don't have a spot for you anymore. I know we had one yesterday, but we don't have one today. And I think that was prematurely done. And again, I go back to the fact that, the schools, the conferences, the NCAA is going to have to figure out a way to make Judge Wilkin happy to get this final approval.
You are in touch and you are dealing with athletes that are trying to make decisions, etc. Why do they not listen to you and others when you have them set up for a pretty good deal and then they go and get an agent that's going to get some of their money and sometimes sign something? Like I saw you and Christy Dosh were back and forth. We've had Christy on. Great reporter too.
Phenomenal.
If any of these words are in your contract, please do not sign before you have an attorney or agent review it. As far as the 3 flags in a contract, how many players are paying attention to that?
Yeah, this is one of the reasons why I'm very appreciative for you guys having me on. You've got a very broad audience. I can't scream this loud enough. I can't stand on the highest mountaintop and have everybody hear me. But look, I'm a certified NBA agent, and in that process, I've represented professional basketball players for nearly 10 years, whether in the NBA, G League, or overseas. I am also, because of my legal background, was appointed to the Agent Regulations Committee by the Players Association.
Mm-hmm.
There is no such thing really in the world of college athletics. I always joke that my dog could be an NIL agent. There are very good ones, and then there are those who are out to, I think, take advantage of people. Any NIL agent agreement that is requiring you to pay 10, 15, 20, I've seen 30% for deals with universities, revenue share, and NIL collective deals, completely unnecessary, in my opinion. Look, I have two buckets. I have the buckets of rev share and NIL collective deals, and then I have a bucket of third-party brand deals. I want to get sponsored by Lululemon. I want to get sponsored by Pepsi, Coca-Cola, whatever. That's a different story. That takes a significant amount of work, a significant amount of creativity from an agent perspective. And I don't have a problem with paying an agent 10, 15, 20% for the creativity that goes into those types of deals and the origination of those types of deals. The NIL collective deals and the rev share deals are very simple, okay? Here's how they happen. Student athlete says, I want to go into the portal. The school has 48 hours to put you into a portal. You either put contact or do not contact. If you put contact, who are all the other coaches contacting? The student athlete, right? Not an agent.
Yep.
In other cases, you have an agent who could make 2, 3, 4 phone calls. They're calling their assistant coaches with whom they have contacts. They're calling head coaches with whom they have contacts, and that's how that works. Look, when you're talking about a $200,000 contract and you're paying somebody 15% of that for the little work that's involved, and then I have to get involved to negotiate the dozens and dozens and dozens of pages and terms of these agreements.
Oh my!
From a legal perspective, I don't really care so much about page 1 that says the dollars, right? That's not my role. My role is to try to protect, from a student athlete perspective, all of these other provisions, right? That's one contract. I talk to Christy a lot. Christy Dosh is great. We try to inform parents about this. She has a Facebook parent group for NIL. I think this is, a hot button issue. Here's how I try to portray this for college athletes. If you go to the NBA and you hire me to be your NBA agent, you can pay me 2% or 4%, somewhere in between, but depending upon the type of contract it is. Same with the NFL. I'm not an NFL agent, but NFL agents know that they're paid somewhere between 3 and 5%. Same with MLB and the NHL. I'm sure MLS has its own agent regulations, right? It's a very small percent. You don't see 10, 15%. You don't see that for originating what is effectively, and I know the NCAA doesn't want to call it this, but this is a player contract, right? The NCAA wants to call it a marketing deal because it's name, image, and likeness. But I think we all know what this really is. So I work with NIL agents who are very, very good at what they do, and they charge 2, 3, 4%, 5 tops, right? Something that is appropriate in the professional ranks, right? If you want to have a separate marketing deal so that you can negotiate your Lululemon deals and your Viore deals and your, deals with a Under Armour or whatever brand, that's fine. You can have your 10, 15, 20%. But, for this type of stuff, for the NIL collective deals, for the revenue sharing deals, it really drives me crazy when I see, these exorbitant fees that are being paid to agents, and some of the times they don't even originate the contract, and then they send demand letters to the client saying, we hear that you have signed with such and such place. We want our 20%. And then I get phone calls and I have to review these agreements, and it's not a good situation. And I understand the NCAA may not want to collectively bargain and do all this type of stuff. What needs to be done is, in my opinion, have a standard for agents, right? I had to pass an examination.
Yes.
To be an NBA agent. And what did that examination test me on? The collective bargaining agreement and the agent regulations. There needs to be some sort of regulations promulgated by the NCAA that's exacting, right? That has teeth, that means something. Otherwise, I mean, you're just going to have kids getting ripped off left and right. I mean, look, as I say to some players, just use your brain. Why are you paying somebody 25% of a $200,000 contract or a $500,000 contract? I mean, just do that math. I mean, 25% of $1 million contract. Did they really perform all that work for the amount that you're going to pay them? No.
Yeah. How many players should just and you're talking about agents who are certified. I mean, that way, and Craig Bowl from the American Football Coaches Association, who's right here in Waco, has said he's begging the NCAA and however they can go about doing it legally to make sure that happens. Because it's just like you said. I saw your latest note. You had a young man, $150,000 deal. You told him don't sign it. He gave the guy 10%, $15 grand right out of his pocket. That didn't have to come out of his pocket basically at all.
And for what? For what? He didn't even originate the deal. The contract, this is the second time this has happened in probably a week and a half. The contract fell into the kid's lap because the coach saw that his name was in the portal, contacted him directly from the portal, communicated directly with. This is why sometimes I say, do players need a NIL agent to go into and come out of the transfer portal? I would say to that, not necessarily, but sometimes. A lot of the times, as I mentioned before, you're in the portal, you're going to get contacted directly by a coach. Mm-hmm. This is not necessarily a negotiation. A lot of these schools, are putting these contracts in front of players with some certains that really don't change, right? You're not going to suddenly negotiate a $200,000 NIL deal into a $750,000 NIL deal for the same player. That generally just doesn't happen. A lot of these deals are kind of, this is what we have, take it or leave it.
Right.
So do you need an NIL agent for that? I don't think so. For some of the guys or players, I should say, because I represent both sides. I have male athletes, female athletes, volleyball, women's basketball, men's basketball, college football. So I try to identify, who really needs the NIL agent. And like I said, I work with some very good ones, both for football and basketball, and they genuinely help the players if it's needed.
So if a school contacts a player, is it as simple as a school, let's just say, it doesn't matter, contacting the player and say, hey, we have $200,000. And the player may talk to his parents or may talk. Is it that simple? They just say, this is what we have, and he can go back and forth with the team? Or is that when you need help, calling Ryan Mulvaney or someone like yourself?
That's how easy it is. Yeah, look, a school will reach out to somebody in the portal.
That makes no sense to do it otherwise. Yeah. Oh my goodness, it's that simple.
Yeah.
Now I know you represent the athletes. Can the schools protect themselves, Ryan? For example, we saw some stuff the last couple of weeks with Nico and Madden Yamaliava. What are your thoughts as someone who represents players, student athletes, about how can schools protect themselves, or can they?
Yeah, there's been a lot of newsworthy stuff going on really since the winter portal with Xavier Lucas. I mean, that was probably the first instance where a university took a hard line position. I think the way, if I'm advising a school, I think the way to do that is, maybe put some sort of buyout clause in a contract, or have some sort of clawback provision. As a lawyer for the college athletes, I try not to tip my hand here to all the universities who may be watching, but I try to shorten the payment period. Right? I don't want it to be an entire calendar year. I want the athlete to get as much money as possible before the transfer portal opens. And why is that? The NCAA bylaws provide college athletes with the express right to enter the portal, like it or not. Look, my alma mater is a Big East university that has been struggling for the last 2 years. We have rebuilt the roster every single season since, right? It's difficult. I understand that from a fan perspective, but from the perspective of someone who regularly represents college athletes and pro, you want to be able to put the athlete in a position to earn as much as they can. And right now it's a year-to-year process. Am I offended if I see a 2-year deal? No, not necessarily, particularly if they're upperclassmen, and that provides a little bit of stability. Like if you're a junior and you only have 2 years of eligibility left, I don't mind seeing a 2-year deal. But if going back to the university side of things, I think that's probably the best way, to have some sort of buyout or have some sort of clawback provision. Like, for example, if your term of payments end, say May 1st or April 15th or something like that, and the college basketball season ends and you enter the portal on March 26th and you transfer out, you're at some point in the beginning of April, you're obviously waiving your right to payments in May. You're obviously waiving some payments in March because you've entered the portal. I don't want to see, total paybacks where a student athlete has to pay everything back that he or she has received from the university, because in my opinion, that student athlete has performed, right, their NIL services throughout the season. So they should be paid for what they've done. Now, I can understand the school's position of, well, we want to claw back a little bit. I get it. That's probably the only way I can see appropriately schools protecting themselves. I've just had an instance not too long ago where a school, who will remain nameless, tried to put a non-compete in front of a player and have the player sign it. A non-compete for a non-employee, number one. And number two, we're a student athlete. You're telling the student athlete that they can't go to a college of their choosing? Like, that's what we're talking about here. So, obviously, the non-compete was a non-starter. You can't, I'm sure there are professionals who are listening to this who are officers or directors of companies, right? And they very well know, from an employment perspective, you can't inject and expect somebody to sign a non-compete on the way out the door that wasn't in their employment contract to begin with. So, a little hard to do that here. Not only the fact that they can go to whatever college and school that they want to do or want to go to and pursue whatever studies they want to pursue, but you can't have non-competes. I mean, that's just, a non-starter. So buyouts and clawbacks are probably the only way that they can really protect themselves from a university perspective, that is.
So if the settlement goes through, and in all likelihood it is, unless, again, the guys who have screwed up college athletics for years continue to do it again, how the $20.5 million goes, at least you have that amount of money to spend. You can spread it out however you want. If you don't have a football program, then my God, your men's basketball team is going to be in pretty good shape, right?
Well, from your lips to God's ears.
And can you still a program boosters, donors, whatever, and I hear about Deloitte as they're like the distribution center, will there still be millions of dollars in NIL money being distributed to players on top of the revenue sharing?
You could have instances like that, sure. Just because you have revenue sharing doesn't mean NIL collectives will go away altogether. Some will, some will be brought in-house, so to speak, to the school.
Yep.
Some will continue to operate, but the clearinghouse is there to purportedly to make sure that there is some sort of fair market value with respect to these contracts. On what they're basing that is beyond me, because this is only really 2.5 years old.
Yep.
So what market is there really? And, I foresee a bunch of litigation as a result of that. Try telling a student athlete that he or she is not worth the value that a NIL collective or a third party brand is willing to pay for you. So
it's crazy. Now, last thing, I know you got to go. My God, you've given us time, and you got trials installed, all that things you're doing. We appreciate it. So what does this fix if it's passed? Are there still going to be lawsuits? Are there? Because I still don't know how the NCAA is ever going to avoid that. Because one of the first things, unless I'm wrong, Ryan, correct me if I'm wrong, that one of the things that the attorney who was the guy who may have been a part of EA Sports or whatever else was that it was going to protect the NCAA if they agreed from being sued. That's impossible to guarantee.
Yeah, I would look. I mean, if you're part of the settlement, then you're obviously waiving your right to, to bring an action against the NCAA or the conferences. But if you've opted out of this settlement, then you're free to do whatever you want. As I just mentioned, I foresee more litigation down the road.
Yeah.
As soon as Deloitte tells somebody, there's your deal is rejected because it doesn't qualify for what we believe is fair market value. Deloitte's getting sued. The NCAA is getting sued.
The school maybe. Yeah.
The school may be getting sued. This whole $20.5 million. Look, there may be lawsuits even after this, because what is happening with this $20.5 million cap is there's a salary cap being thrust upon college athletes that has not been collectively bargained. I understand that there's a settlement, and look, I deal with settlements all the time. This is how, parties come together and end litigation. But what is effectively happening here is a salary cap is being imposed, not only with this settlement, but also with third-party brand deals, right? Because Deloitte is now responsible for otherwise capping what they believe should and shouldn't be paid to an athlete. So I see more lawsuits down the road. Look, we have lawsuits now with respect to the eligibility issues. One of my good friends here in New Jersey just filed one on behalf of a player at Rutgers. So I see more litigation. Look, this case hopefully will settle. Hopefully, roster limits will be addressed so that they don't negatively impact current college players. And look, this will be resolved, but that's not going to resolve everything.
Right.
With the NCAA.
Ryan, last thing is, okay, and I know you have players, athletes, student athletes, NBA and college, but if you got into a room with the NCAA leadership, Baker, whoever else, and it was off the record, which I'm then asking you to not put, would you be able to repeat what you tell them of how they have screwed this thing up for so many years?
Look, the one thing I'll say about Charlie Baker is I think he listens. Right. I don't think, I mean, look, we've seen him get grilled by Congress. We've seen, here's who had the best timing. Emmert. He knew when to get out. Right. So, look, I would be happy to have a conversation with Charlie. I think he's somebody you could, sit down and have a frank and genuine conversation with. He doesn't strike me as anything but. I think he's made himself readily available. I wouldn't have a problem having these conversations with NCAA leadership, but they have to listen at the same time. I'd welcome the invitation. Senator Cruz is having hearings on Congress. I'd welcome the invitation to speak with him. And any other member of Congress who is trying to step into this arena. There are some good people who on the college athlete side who have very good ideas and I think should be heard.
Doesn't Congress have more important things to do than?
One would think.
Yeah.
One would think.
Yeah. Hey, Ryan, we've had Christy on, we've had others on, we've had Darren Heitner on.
Oh, Darren's great.
Yeah, and we've had you on among others. It's great to have you. Thank you so much. I know you got an incredible busy schedule, but the knowledge you gave us is what we needed to hear too. And thanks for your time today, buddy.
I appreciate you having me on. Thank you very much. I look forward to being on again.
Yes, sir. We if they do the settlement, would you come on after it's over to kind of explain what it? Okay, let's do that.
Yeah,
all right,
absolutely. Be happy to.
Thank you, Ryan Mulvaney, with us again, an attorney, sports law, NIL, litigation, and does quite a bit more.